Start para. Both these petitions are filed by the petitioners, thereby challenging the orders passed by the First Appellate Authority in miscellaneous civil appeal numbers 91 of 2016 and 36 of 2019. Petitioners are the original defendants in a suit filed by the deceased bearing regular civil suit numbers 317/2000 and 318/2000. In the said suit's petitioners raised issue of tenancy, and accordingly an issue to that effect was framed, and the suit was kept sine die till the disposal of the decision of tenancy court on such issue, though initially the learned civil court did not refer to the tenancy issue immediately after framing it. Such issue was referred to the Mamlatdar somewhere in the year 1997. However, it is a matter of record that sole plaintiff expired on 23/8/1995. Matter was taken up before the Mamlatdar, and subsequently sole defendant expired on 15/5/2005. Para. It so happened that though the suit was kept sine die and the proceedings were taken up before the Mamlatdar in connection with tenancy issue, legal heirs of the original plaintiff and original defendant were brought on record in the tenancy case pending before the Mamlatdar. No application was filed in the suit by the respective parties for bringing legal heirs. It is so further happened that the jurisdiction of the Mamlatdar to consider the tenancy matters would then shifted to the civil court, and accordingly proceedings before the Mamlatdar were brought back to the civil court wherein suit was pending. Thus, along with the tenancy issue, suit was also taken up, and at that time it was realized that legal heirs remained to be brought on record in the suit, though somewhere on 31/1/2009, advocate for the defendant filed an application under Order 22 Rule 10A of CPC informing that sole defendant expired on 15/5/2005. It is also a matter on record that no notice was issued to the learned counsel for the plaintiffs of such intimation, since the suit was kept sine die. Application for bringing legal heirs filed in the suit was contested by the defendants, wherein learned civil court passed an order thereby dismissing both the applications filed at Exhibits 22 and 27. Para. Petitioners then filed appeals bearing miscellaneous civil appeal number 91 of 2016 and 36 of 2019, which came to be allowed by the impugned order, thereby condoning the delay and setting aside abatement and bringing legal heirs of the parties on record which are challenged in these proceedings. Mr. Lotlikar would submit that Barsoba expired in the year 1995, whereas reference by the civil court was much subsequent to it, and thus it was without jurisdiction as sued abated automatically. He would submit that such reference itself to the Mamlatdar is bad in law, as by that time the suit stands abated for failure to bring on record legal heirs of the sole deceased plaintiff. No application was filed within time in the civil suit for bringing the legal heirs. Findings therein are based on the settled propositions of law and therefore cannot be disturbed in the supervisory jurisdiction of this court. Accordingly, both the petitions must fail and stand dismissed. Stop.